Members, the question is that the motion be agreed to.
Mr. Speaker.
Jacinda Ardern.
Mr. Speaker, I want to begin by reflecting on some of the provisions we chose to highlight it as a party in the first reading of this debate. As I put on the record then, and as my colleagues did as well, this bill brings to fruition something that Labor has campaigned hard for, not just as an opposition party, but actually something we had on the agenda as government. So we're talking over 8 years ago now that Labor drew a line in the sand and said absolutely the age of care and protection in this country needs to lift. And not just the age of care and protection. We didn't view young people as people that we should treat differently if they're in care and protection than if they're in our youth justice system. Our view was, if you are 18 and under, you are a child. And that's not just our view, that's an international view. That is the international standard. It's the standard we've signed up to in the UN Convention on the Rights of the Child. And if we take the view that you are a child when you are in the care of the state, then you are a child if you ever come before a court in this land. Now, we took that view over 8 years ago, and we've pushed for it ever since. We've run petitions, we've had amendments in this House, we have campaigned hard alongside organisations like Dingwall Trust, and I acknowledge the huge work, not just by the people who work within Dingwall, but the young people in their care who have been at the forefront of this debate. I acknowledge that they put their stories out in the public to see this come to fruition. So our support of that provision, even though it's just for care and protection, has been unwavering. And that was the basis fundamentally on which we gave our support to this bill at first reading. That strength of feeling should highlight equally, on the flip side, our strength of feeling for now, why we are putting our support under a condition. This bill doesn't just include an increase in the age of care and protection, which is fundamental. It also includes what the Minister has broadly brushed over as some cursory delegation of powers away from social workers. These are not just cursory delegations, Mr. Speaker, and I want to spend a little bit of time talking today about what Section 7 of this bill does, because it was really only when we fully canvassed this bill at Select Committee that we saw the gravity of what this bill was proposing. Social workers in this country hold a number of statutory powers which are literally only shared between them and police officers. And there is a good reason for that. They are some of the most powerful, potentially damaging, if used incorrectly, powers that the state has. The ability to remove a child from a family is an overwhelming power, and one that should be treated with accountability, transparency, and a huge level of regard for the professionals who are asked to execute that power. At the moment, we have partitioned off in our laws that we only believe those warrants should really be exercised involving the courts, police officers, and social workers. What this bill does is allow those powers to be transferred to the Chief Executive, who can then delegate those powers to any professional that the Chief Executive deems necessary to delegate those powers to. Now, let me just reference exactly the way that it is articulated. It says delegations and subsections, basically it's a process that has to be gone through. The delegations referred to in this bill and sub-delegations must be publicly notified. And information about all delegations and sub-delegations must be made available on an internet site, maintained by the department, and be available for inspection at the head office of the department free of charge until any case the delegation or sub-delegation is revoked. The only other requirements on the Chief Executive in making this delegation is for the Chief Executive to decide if they're not a social worker, the Chief Executive must be satisfied that the person is appropriately qualified to perform the function. And if they're outside state services, so therefore not a professional employed by the state, that they must just have a contract, some contractual obligations. There is nothing in here that stipulates what an appropriately qualified person must be. Nothing. It is simply for the Chief Executive to decide. And if they're not, for instance, someone working with the state, not, for instance, a medical professional employed by a DHB, they simply have to be bound by a contract. Well, Mr. Speaker, we have a number of organisations bound by contracts in this country. A number of them have had contracts removed from them simply because they've not exercised them properly. Serco is one that comes to mind. Now, some might think that in referencing Serco, I'm simply being inflammatory. But I want to talk about what the delegations that we're talking about at the moment, which are just numbers in a bill, actually allow these unknown professionals to do. The bill sets out in 7BA that the Chief Executive may delegate his or her functions and powers under Section 39, 40, 122, 157, 181, 205, 386 in the SIFS bill. They're just numbers. Feels meaningless, perhaps. What harm could be done by a few clauses? Let me tell you. Section 39 of the SIFS Act is the place of safety warrants. Those are the provisions that say that any district court judge can issue an officer under the Search and Surveillance Act the ability, if they are satisfied on reasonable grounds for suspecting that a child or young person is suffering or is likely to suffer ill treatment, neglect or deprivation, they can issue a warrant to a constable or a social worker that then allows them to enter and search by force any dwelling, any building, any vehicle, any premises. And if that person, a constable or social worker, believes on reasonable grounds the child or young person has suffered or is likely to suffer ill treatment or serious harm, can remove or detain them by force if necessary, the child or young person from the place that they are and place them in the custody of the Chief Executive. Mr. Speaker, removing a child by force because they have used their professional discretion that they are at risk of harm is something that we must enforce vigorously and ensure no one other than a qualified professional is able to make that decision. Now, who is it that the Minister is proposing will have the professional or contractual arrangement to adequately do that job? And if you cannot tell me now in this House, with a good rationale and justification, who that person is, then we will not sign our name to it. Tell us who it is. Because otherwise, we will lob claims across the other side of this House that it's potentially a Serco, or an armour guard, or any number of contractors who this government has deemed fit to enact similar provisions in our corrections laws. So if you cannot tell me who it is, what faith can we have that that person is qualified to exercise that power? Now, that's just one of them. That's just Section 39. Let's read out Section 40, headed Warrant to Remove Child or Young Person. Where an application or declaration under 67 has been made in respect of a child or young person, a district court or issuing officer may, where there are reasonable grounds to believe that a young person or child is suffering or is likely to suffer ill treatment, neglect, abuse or harm, issue a warrant authorising a constable or social worker to search for that child. So then we've got search powers, and I go on, Mr. Speaker. That's just 39 or 40. 122 is the power of enforcement of access rights to take possession of a child and enforce an access order to say that some other caregiver should have access to that child, uplift a child and take them to the person who has that access order. Power clause 157 is ensuring a child physically is at a hearing. Section 181 relates to psychiatric care. 386 relates to search warrants and recovering a child who has absconded. Now, the examples I keep hearing from the government around the kinds of professionals they want engaged in these delegation of powers are things like paediatricians. You are not telling me that a paediatrician is going to be going and searching out a child who has absconded. Of course they won't. So who are these powers for, Mr. Speaker? So today, Mr. Speaker, I am informing this House that unless we have significant reform of these powers, the removal of the delegation, or at least the removal of any delegation that allows a child to be removed by any professional other than a constable or social worker, then we are going to have to remove our support of this bill. And it is with a heavy heart that I say that, given how important lifting the age of care and protection is to the Labour Party. But that's the choice National has given us.
Matt,